I will call this meeting to order of the Senate Judiciary Committee on Thursday, March 11th of 2021 in the 81st legislative session. Would the esteemed secretary please call the roll?
Vice Chair Cannizzaro.
Here.
Senator Orenshaw.
Here.
Senator Harris.
Here.
Senator Settlemyre.
Here.
Senator Hansen.
Here.
Senator Pickard.
Here.
Chair Scheibel.
Here. Thank you so much. And if the record would also please reflect that we have Pat Guinan with us from the Legislative Counsel Bureau, and our committee counsel is busy drafting legislation, so he is not able to join us today. As always, we will take questions back to him that need to be answered by legal counsel if there are any. And today on our agenda, we have a work session on 5 different bills. I think we have subject matter experts or sponsors here for all of them to answer questions if there are any. And the work session document has been posted on Nellis and has also been provided to all of the members of the committee. With that, I will turn it over to you, Mr. Guinan, to walk us through the work session document, please.
Thanks, Madam Chair. For the record, Patrick Guinan, Committee Policy Analyst. As the Chair mentioned, we have 5 bills today, beginning with Senate Bill 7. I will just start going through them. Stop me if you'd like. Senate Bill 7 is a committee bill on behalf of the Supreme Court that was heard by this committee on February 4th. It provides that an order for protection against domestic violence, harassment in the workplace, high-risk behavior, sexual assault, or stalking, aggravated stalking, or harassment is sought against a child under 18 years of age. The juvenile court has exclusive jurisdiction over the action, and it makes conforming changes to remove jurisdiction from other courts, and provides that the changes in the bill apply to orders issued after October 1 of 2021. The judicial branch has proposed an amendment that's attached for the members' review on the following page. To summarize, the amendment clarifies that the district court, which by statute is the juvenile court, has jurisdiction over protection orders where a minor is the adverse party. It clarifies that a hearing master may hear these matters, which is already permissible under statute. It removes contempt of court as a matter that can be heard in relation to a violation of an order, as this is not within the statutory framework set forth for juvenile courts in Title V of the NRS. And it deletes language from the bill requiring that orders be submitted to schools attended by the protected party and by the adverse party. And that's all I have, Madam Chair. And I believe that John McCormick from the court is with us today if the members have questions. Thanks.
Thank you. And I also just wanted to put a clarification on the record and confirm with Mr. McCormick that my understanding is correct. I know that the court worked with a lot of stakeholders on this bill to make amendments that everybody needed. It's my understanding that the language is still permissive for the appointment of counsel for one of these juveniles, and that our public defender's offices in the North and South are in disagreement on that. So the bill does not reflect a complete resolution to all of the stakeholder issues, but it does reflect a permissive appointment of counsel for juveniles. Is that correct?
Yes, thank you, Chair Scheibel. John McCormick with the Supreme Court AOC for the record. That is accurate. The public defender's offices in Washoe and Clark County were not able to come to an agreement. I did work with them in attempts to get the language regarding appointment of counsel cleared up. So we decided to go ahead and leave the permissive language that existed in the bill in there rather than make any amendments.
Thank you. And it looks like Senator Pickard also has a question. Go ahead.
Thank you, Chair Scheibel. I really do like the amendment. It resolved all but one of my concerns, and that is just if we're doing a blanket exclusive jurisdiction and someone had conditions of probation that lasted 3 years, we're bringing a 22-year-old back to juvenile court. But other than that, I like the amendment, so I'll be voting yes with a reservation.
All right, any other questions? In that case, I would entertain a motion to amend and do pass.
So moved.
We have a motion from Senator Harris
Second.
and a second from Vice Chair Cannizzaro. Any discussion on the motion? Senator Orenshaw.
Thank you, Chair. I just wanted to let the committee know that I am a deputy public defender. I am employed at the Clark County Public Defender's Office in the Juvenile Division. Reaching out to our legislative council, I've been told this does not affect me any differently than anyone else similarly situated, and that I'm okay with participating in the discussion and voting on this bill.
Thank you. If there's nothing else, then I will ask that the secretary please do the roll call vote.
Vice Chair Cannizzaro.
Yes.
Senator Orenshaw.
Yes.
Senator Harris.
Yes.
Senator Settlemyre.
Yes.
Senator Hansen.
Yes.
Senator Pickard.
Yes.
Chair Scheibel.
Yes. And I believe that that is a unanimous passage of SB 7 with an amendment. Is there a volunteer to take the floor statement? Not seeing a volunteer, I will volunteer Senator Settlemyre this floor statement. And with that, I believe we are ready to move on to SB 19. If you would lead us through the work session document, Mr. Guinan.
Thanks, Madam. Excuse me. Thanks, Chair Scheibel. Again, Patrick Guinan for the record. As you mentioned, we're on Senate Bill 19 now, which is a committee bill on behalf of the Records, Communications, and Compliance Division of the Department of Public Safety. The committee first heard this bill on February 8th. Senate Bill 19 establishes provisions in accordance with federal law, allowing certain qualified entities to obtain information on the records of criminal history of employees, volunteers, applicants, independent contractors, and vendors of the entity who have access to children, elderly persons, or disabled persons. Qualified entity must create an account with the repository for records of criminal history, provide any person subject to these requirements written notification of his or her rights, and obtain a signed waiver prior to conducting a record screening. And that person's fingerprints must be submitted to the repository and forwarded to the FBI as part of this process. Qualified entities must determine after receiving information under these provisions whether the person is fit to have access to vulnerable persons named above. The bill also contains some liability protections for the qualified entity and the state and its political subdivisions, agencies, and employees regarding this process, and it authorizes the repository to audit qualified entities that submit requests for screening for compliance with all applicable state and federal laws. The Records Repository has proposed an amendment which is attached on the following pages along with an explanatory memorandum. The amendment is intended to ensure that Nevada statute complies with federal authority and provide clarification where the bill's original language was deemed overly broad. Specifically, there are a few bullet points describing the amendment. It replaces the phrase independent contractor or vendor with the term covered individual in section 1.2 of the bill. It strikes federal language regarding exemptions and replaces it with the phrase is otherwise not confidential pursuant to statute or law in section 1.4. It broadens language to cover pending criminal charges in section 1.5. It narrows language relating to liability by referring to the quote unquote accuracy of any information included or omitted from records in section 1.8. And it adds language requiring qualified entity to retain signed waivers for one audit cycle as determined by the department for the purposes of auditing these entities as described in section 1.9 of the bill. And that's all I have, Chair Scheibel. And I believe there are actually several representatives from DPS and other entities available for questions today. Thanks.
Fantastic. Do any members of the committee have questions for the sponsors or subject matter experts? In that case, I would entertain a motion to amend and do pass.
So moved.
Second.
I believe that was a motion by Senator Pickard and a second from Senator Orenshaw. If the secretary would please take the roll call vote.
Vice Chair Canizaro.
Yes.
Senator Orenshaw.
Yes.
Senator Harris.
Yes.
Senator Settlemyre.
Yes.
Senator Hansen.
Yes.
Senator Pickard.
Yes.
Chair Scheibel.
Yes. And with the unanimous vote, the motion carries to amend and do pass SB 19. And is there a volunteer to take the floor statement? I see Senator Pickard's hand. Sorry, Senator Hansen. Senator Pickard was faster than you. So Senator Pickard will get the floor statement on SB 19. And that takes us to SB 31. Mr. Guinan.
Thanks, Chair Scheibel. Again, Patrick Guinan for the record. We're now on Senate Bill 31. This is another committee bill on behalf of the same entity as 19, the Records, Communications, and Compliance Division of DPS. It was heard by this committee on February 8th. Senate Bill 31 revises provisions relating to the Central Repository for Nevada Records of Criminal History. The bill expands the definition of a record of criminal history to refer to a prosecuting attorney rather than the narrower definition that contained district attorney, and it eliminates the requirement for the repository to prepare and post certain reports on its website, instead requiring the repository to provide electronic access to the statistical data on the website and to include data on certain orders for protection and on crimes against older or vulnerable persons. It also requires the repository to provide an authorized entity the criminal history of a person generally, rather than limiting that information provided to convictions only or to incidents for which the person is currently involved in the criminal justice system. And there are no amendments to the bill. Chair Scheibel, that's all I have.
Thank you so much. Are there any questions on SB 31? All right, I would accept a motion to do pass.
So moved.
All right, we have a motion from Senator Pickard, a second from Senator Orenshaw. If the secretary would please take the roll call vote.
Vice Chair Canizaro.
Yes.
Senator Orenshaw.
Yes.
Senator Harris.
Yes.
Senator Settlemyre.
Yes.
Senator Hansen.
Yes.
Senator Pickard.
Yes.
Chair Scheibel.
Yes, and with another unanimous vote, the motion to do pass SB 31 carries. Do we have a volunteer to give the floor statement?
Pick me, teacher.
All right, Senator Hansen, you can do the floor statement on SB 31. And that takes us to SB 72.
And thanks, Chair Scheibel. Again, Patrick Guinan for the record. We're now on Senate Bill 72, as you mentioned. This is a committee bill that was brought on behalf of the Real Estate Division of the Department of Business and Industry. The committee heard it on the 15th of February. Senate Bill 72 revises provisions concerning common interest communities. More specifically, it provides that a limited purpose association must comply with requirements of the Uniform Common Interest Ownership Act pertaining to the establishment and foreclosure of a lien for assessments. It revises provisions concerning fines that may be imposed by an executive board of a unit owner association. Specifically, the bill stipulates that when a violation causes an imminent threat to health, safety, or welfare, fines cannot exceed $1,000 for each violation or a total amount of $1,000 per hearing. And when a violation does not cause a threat to health, safety, or welfare, fines cannot exceed $100 per violation or a total amount of $1,000 per hearing. The bill also eliminates the requirement that an executive board may only meet in executive session with an attorney for the association on matters relating to proposed or pending litigation if the contents of the discussion are protected by attorney-client privilege. It provides instead that the board may meet in executive session with an attorney on matters that are protected by attorney-client privilege. And it provides that a person who may be sanctioned for an alleged violation is entitled to receive written notice of the board's decision regarding the violation within a reasonable time after the decision is made. and that the period to cure a violation before it becomes a continuing violation does not commence until the date on which the notice of the board's decision is provided to the person. The committee will remember there was discussion of an amendment with the sponsor when the bill was heard. And the sponsor has submitted an amendment in response to those concerns, and it's attached on the following pages for the committee's review. The amendment deletes language in subsection 2B of section 2 of the bill, providing for monetary limits on the fines an association may impose, as I summarized above. It replaces that language with provisions allowing the Commission for Common Interest Communities and Condominium Hotels to adopt regulations, establishing criteria to be used in determining whether a violation poses an imminent threat to health, safety, or welfare, the severity of such a violation, and limitations on the amount of fines that an association may impose. And that is the substance of the amendment. Chair Scheibel, and I believe that we have Administrator Chandra with us today to answer questions if the committee has any. Thanks.
Thank you. And I already see a hand up. Huge surprise. It's Senator Pickard.
Indeed, I almost said Your Honor again. I'm about to elevate your status again. I just wanted to say I appreciate the amendment. I really like the idea of sending the fine limitations through the regulation process, where we're going to have an opportunity to really vet the concepts and whether or not they make sense, and at that point, what amount makes sense. So I'm now in full support of the bill.
Great, thank you. Senator Settlemyer?
Thank you, Madam Chair. I appreciate the opportunity. Like my colleague, the amendments have really helped. One of the things that concerns me, though, in the last portion of the amendment, it says the Commission may adopt regulations establishing the criteria used in determining. May. Part of me wants to almost say that, you know, what everybody think about the idea is, until you adopt those regulations, you can't change your fee structure up. In other words, you want to charge more in fees or fines, fine, but you have to actually have a hearing and adopt regulations establishing the criteria to do that, rather than may. I don't know. I was just throwing that out there for discussion.
Mr. Chandra, do you want to respond?
Thank you, Chair Scheibel. Sharat Chandra, Administrator for the Real Estate Division. The May was put in there with the understanding that the regulation process takes a while. So without upending anything, the way things are being done now will be followed, and the intent is to put a regulation in place. We just anticipate it might take a little while to do it, and there's going to be a lot of discussion. And so we just don't want to kind of pull the rug from under what the current status is. So we leave it as that. We go through the regulation process, and then when the regulation is adopted, that goes into effect. That was at least the thought behind it.
Appreciate that. This is Senator Settlemyer for the record. Appreciate that explanation. And I'll let it go for now, but hopefully future legislators around here maybe start thinking about the concept of saying, yeah, we'll let you raise fees and fines and things of that nature, but you have to do something first rather than just getting to do it lock and stock. Anyways, that was my concern. Thank you, Chair.
Absolutely. Any other questions on the bill? Not seeing any, I would entertain a motion to amend and do pass.
So moved.
All right.
I'll take the second.
Okay. So we have a motion from Senator Orenshaw to amend and do pass SB 72. We have a second from Senator Pickard to amend and do pass SB 72. Any discussion on the motion? Not seeing any hands raised, I will ask the esteemed secretary to please take the roll call vote.
Vice Chair Canizaro.
Yes.
Senator Orenshaw.
Yes.
Senator Harris.
Yes.
Senator Settlemyer.
Yes.
Senator Hansen.
Yes.
Senator Pickard.
Yes.
Chair Scheibel.
Yes. And that makes the motion unanimous to amend and do pass SB 72. And is there a volunteer for the floor statement? All right, I will give it to Senator Harris, because I think that the next one is going to the other person who volunteered. Moving on to SB 95.
Thanks, Chair Scheibel. Again, Patrick Guinan for the record, Committee Policy Analyst. This is our final bill on the work session for today. It is Senate Bill 95, as you mentioned. It's a bill sponsored by Senator Orenshaw and heard on this committee on February 22nd. This is the traditional omnibus bill sponsored by the business bar in the state of Nevada. So I don't know that you want me to read through this entire summary. I will, if you like. Senate Bill 95 is the omnibus measure that revises provisions governing Nevada business entities. Among other provisions, the bill transfers from the clerk of the court to the party who serves the document responsibility for mailing certain documents to a company's management. It moves the definition of quote unquote publicly traded corporation to a different section of statute to make it more generally applicable. Allows a corporation to include a federal forum selection clause in its articles of incorporation or bylaws. It clarifies fiduciary duties for corporations. It expands the definition of distribution regarding classes or series of shares. It revises provisions concerning the ability of a corporation to hold virtual meetings and who may attend those meetings. It revises provisions concerning the applicability of certain voting agreements and time limits placed on such agreements, as well as clarifying voting requirements for certain types of entities. It expands a corporation's ability to indemnify managers in certain circumstances. It clarifies that certificate of membership interest requirements for some associations do not apply to common interest communities. It clarifies the terms distribution and in interest as relates to limited liability companies and their members. Revises provisions concerning notification of stockholders, concerning actions that create dissenters' rights. Clarifies provisions governing a stockholder's demand for payment of shares and requires the stockholder to file a statement of intent under certain circumstances. The committee will remember that when we heard the bill, Mr. Kim provided a thorough outline of the bill's provisions, and that outline also included discussion of an amendment that was proposed initially along with the bill by Senator Orenshaw. All those documents are attached for the committee's review. In addition, there are two amendments for consideration by the committee today. The first is the one I just mentioned that Senator Orenshaw proposed at the initial hearing on the bill. That's largely a technical amendment, and it was included in the presentation, so I won't go through it extensively. I think it's been discussed. But then the second amendment that we also have under consideration today was proposed more recently and is from the executive committee of the bar, the business bar. And that second amendment addresses concerns that were discussed during that initial hearing and also were voiced in a letter that is attached from the representatives of the Nevada Registered Agent Association. And this regards the proportion of interest certain members of an entity retain. And as stated by the executive committee in the memorandum they submitted, the additional amendment, which is also attached, seeks to replace the proposed changes to section 22 through the Nevada Revised Statutes 86.291 with language that both retains the concept of management being vested in members and preserves the proportionality of members rather than establishing a default rule of a majority as is currently drafted in section 22 of the bill. And I believe that we have Mackenzie Warren with us today, who was present when the bill was initially presented, if there are questions. And that's all I have, Madam Chair.
Thank you, Mr. Guinan. I actually have some questions of my own. This is a 48-page work session document, and I wanted to clarify, I think this question is actually for Senator Orenshaw. It looks like there are 3 different proposed amendments, one from the sponsor, one from the business law section of the bar, and one from the Registered Agents Association. Is that correct, Senator Orenshaw?
Yes, Chair. I believe there are 3 amendments in the work session document, and I appreciate you giving me the time to try to work with all the stakeholders, Mackenzie, Robert Kim, Albert Kovacs, and I want to thank Mr. Anthony and everyone else in the legal division for trying to help us address all the issues. Senator Pickard brought up some points that he was concerned about. I know I've tried to work with him on his concerns. I've tried to address the city of Henderson's concerns. I believe that this has satisfied many of the speakers at the hearing. And as to the registered agents, I know we've been working with them, and I'm committed to keep with them. We did get their proposed language this morning, and I haven't had time to get feedback from the business law section in terms of that, but I am committed to keep trying to work with them. And I'd ask that my preference would be that the committee consider the amendments that I proposed in the business law section proposed.
That was going to be exactly what I was going to say. And I'm not sure if the registered agents are with us today at this meeting, watching or via phone. It seems there was a miscommunication about the status of their amendment. And so I'm going to instruct the committee that we will not be considering their amendment today. As Senator Orenshaw indicated, it doesn't mean that he's unwilling to work with the registered agents and that there might not be an amendment coming to the floor. But for today's purposes, after we answer the other questions, the only amendments I will be considering are the ones proposed by Senator Orenshaw and by the business law section of the Bar Association. But now you know where the registered agents stand and what they would like to see as well. And Senator Settlemyer, do you still have a question?
Thank you, Madam. Thank you, Chair. I appreciate that. I was just going to ask the question of the Senator exactly what you did. Which of these amendments are in conflict with one another, and does he consider all of them friendly? In that respect, I have no further questions. I know for a fact that Mr. Orenshaw is a very good legislator and will continue to work with registered agents to try to figure out a way to alleviate their concerns along this process. And whenever you're willing, I'd entertain the amend do pass with the two requisite amendments by Mr. Orenshaw and the State Bar. But obviously you have other questions first. Thank you, Chair.
Thank you. I don't see any other questions. So I will accept Senator Settlemyer's motion to amend SB 95 with the amendments submitted by Senator Orenshaw in the business law section of the Bar Association. Senator Pickard has seconded this motion to make two amendments to Senate Bill 95 and do pass. And with that, is there any discussion on the motion? All right, if the secretary would please take the roll call vote.
Vice Chair Cannizzaro. Senator Orenshaw.
Yes.
Senator Harris.
Yes.
Senator Settlemyer.
Yes.
Senator Hansen.
Yes.
Senator Pickard.
Yes.
Vice Chair Cannizzaro.
Yes.
Chair Scheibel.
Yes. And with that, we have unanimously moved to amend and do pass SB 95 with the two amendments previously mentioned. Senator Orenshaw, will you take the floor statement?
Yes, thank you.
will.
Thank you, Chair.
And that concludes our work session for today. That leads us to our last item on the agenda, which is public comment. Broadcast, do we have anybody with us for public comment today?
Thank you, Chair Scheibel. To provide public comment this afternoon, please press *9 now to take your place in the queue. Once again, if you'd like to give public comment this afternoon, please press *9 now to take your place in the queue. And Chair, the phone lines are open and working. However, there are no callers to give public comment at this time.
All right. In that case, that concludes our meeting for today. And we will be meeting again on Monday at 1 p.m. or the call of the chair. And with that, we are adjourned. Thank you.